The different types of intellectual property and how they're protected. Intellectual property refers to creations of the human mind that are given legal protection. These creations can range from literary and artistic works to inventions and symbols. Intellectual property is an important aspect of modern-day society as it provides individuals and companies alike with the right to protect their hard work, investments, and innovations. In this article, we will take a closer look at the different types of intellectual property and how they are protected. Copyrights. Copyrights are one of the most well-known forms of intellectual property. They are legal protections that give creators the exclusive right to use, distribute, or sell their original works of authorship. Such works can include literary works, such as novels, poetry, and plays, musical compositions, artistic works, such as paintings and sculptures, and even computer software. Copyrights are generally granted automatically to creators upon the creation of their work. However, it is always recommended that creators register their works with their country's copyright office to obtain added protection and benefits. Copyrights are protected for a specific duration of time, which varies between countries. In the United States, for example, copyrights are protected for the life of the author plus 70 years. Trademarks. Trademarks are another important form of intellectual property. They are legal protections for branding elements that distinguish a company's goods or services from those of competitors. Trademarks can include names, logos, slogans, and even sounds. Trademarks are granted upon registration with the relevant government body, such as the United States Patent and Trademark Office. With a registered trademark, a company has the exclusive right to use their branding elements in any way they see fit. This includes using them on products, advertising materials, and various forms of media. Patents. Patents are legal protections granted to inventors of new and useful products or processes. Unlike copyrights and trademarks, patents are not automatically granted. Inventors must file a patent application with their country's patent office, which will examine the innovation and determine its patentability. Patents are often granted for a specific duration of time, which varies depending on the type of invention and the country in which it was patented. In the United States, for example, patents are granted for 20 years from the date of filing. Trade secrets. Trade secrets are a form of intellectual property that protect valuable information that a company does not wish to disclose to the public. This can include things like formulae, processes, and designs. Unlike copyrights, trademarks, and patents, trade secrets do not require registration with a government office. Instead, companies must take steps to ensure that their trade secrets remain confidential. This can include measures such as restricting access to sensitive information to only those who need it, using non-disclosure agreements, and implementing strong security protocols. Enforcement of intellectual property rights. Enforcing intellectual property rights is crucial to protecting the hard work of creators and innovators. There are a number of ways in which intellectual property rights can be enforced, depending on the type of intellectual property being infringed upon. Copyright infringement can be enforced through legal action. This can include demanding that an infringing party cease the use of copyrighted material, seeking injunctions against the infringing party, and even pursuing monetary damages. Trademark infringement can also be enforced through legal action, including injunctions and monetary damages. However, in some cases, trademark owners may choose to enforce their rights through alternative dispute resolution methods such as arbitration or mediation. Patent infringement can be enforced through lawsuits, injunctions, and monetary damages. However, given the high costs associated with patent litigation, some patent owners may choose to license their patents instead to other companies for royalties. Trade secret infringement can be enforced through lawsuits, injunctions, and other legal remedies. However, these types of cases can be particularly complex and costly given the difficulty in proving misappropriation of confidential information. However, the concept of intellectual property can also be a contentious one. Some argue that the current system places too much emphasis on protecting the interests of creators and innovators, at the expense of wider society. As a result, there is ongoing debate about how to balance the interests of intellectual property owners and the public. Some argue for stronger safeguards for intellectual property, while others argue for greater flexibility and accessibility. One avenue for addressing this issue is through the use of open source licenses. These licenses allow creators to share their work with others, while still retaining some control over how it is used and distributed. This can promote collaboration and innovation, while also protecting the rights of creators. Another approach is through the use of innovative business models that emphasize sharing and collaboration. For example, some companies now offer their products and services for free, while making money through alternative means such as advertising or data collection. Ultimately, the protection and enforcement of intellectual property rights will continue to be an important issue for individuals, companies, and society as a whole. In recent years, the rise of digital technology has brought new challenges for the protection of intellectual property. The ease of copying and distributing digital content has made it more difficult for creators to control the use of their works and has led to widespread piracy. To combat this problem, many countries have implemented laws targeting digital piracy and illegal file sharing. These laws can include fines, criminal penalties, and even the blocking of websites or internet access. However, some argue that these laws go too far and can infringe upon the rights of individuals to access and use information and creativity. This has led to debates about issues such as fair use and access to information, with some advocating for more flexible laws and regulations. Another issue that has arisen with the growth of digital technology is the role of intermediaries such as social media platforms and internet service providers. These intermediaries can play a major role in the distribution of copyrighted material, and there are ongoing debates about their responsibilities and liabilities for copyright infringement. However, there is ongoing debate about the effectiveness and fairness of these laws. The concept of intellectual property has implications and applications that extend far beyond the world of business and the creative arts. For example, intellectual property law can also play an important role in public health and scientific research. In the realm of public health, intellectual property protections can be both a benefit and a barrier. On one hand, patent protections can incentivize the development of new drugs and medical technologies, leading to better health outcomes and improved quality of life for patients. On the other hand, the high costs associated with patented medications can make them inaccessible to many people, particularly in low-income countries. This has led to debates about the role of patent protections in promoting public health and the importance of access to essential medicines. In scientific research, intellectual property protections can also be a double-edged sword. Patents can provide financial incentives for researchers and companies to invest in new technologies and innovations, leading to increased scientific knowledge and progress.